Good morning, colleagues, excellencies, ladies and gentlemen. I declare open the 3230th meeting of the Committee on the Elimination of Racial Discrimination. I will start with two announcements. The first one is that there is an orange alert for today for the heat wave. It will reach 35 degrees centigrade with high levels of humidity. So please do not forget to rehydrate often. The second announcement is that this evening at 8:20, there will be an eclipse. So if you're interested, the suggestion is that you should go to the left bank of the lake and the river and got to a higher elevation to be able to see when the sun goes down behind the Jura Mountains. Having said that, I warmly welcome this morning the delegation from India appearing today before the committee, led by His Excellency Mr. Tushar Mehta, Solicitor General. We are going to continue our constructive dialogue that we started today, and we are going to focus on the following themes in segment 3 and 4. The segment 3 will focus on the situation of ethnic and ethno-religious groups and indigenous peoples, and the Convention in Domestic Law and the institutional and policy framework for its implementation. Segment 4, situation of migrant workers, refugees, asylum seekers, and stateless persons, human rights education. Again, a kind reminder on the need for the strict management of time. We want to cover as much as possible, but to be able to do that, we have to be very strict in our interventions. Without further delay, I'll give the floor to Madame Stavrinaki, the country rapporteur, for her questions. And Madame Stavrinaki, you have the floor for 20 minutes.
Thank you, Mr. Chair, and let me warmly welcome back the esteemed delegation. So yes, we focus on a few among the issues that you just mentioned. I'm starting with the situation of ethnic, ethno-religious groups and indigenous peoples. So the report, the State Party report, is comprehensive on scheme and budgetary data, reserved seat, employment reservation figures, the PMAYU housing, etc. But includes funding figures instead of clear outcome or segregation reduction indicators as requested by the committee in our previous dialogue. Since 2014, Sachar Committee recommended minority welfare infrastructure has been rolled back. The Maulana Azad Fellowship was discontinued. Scholarships were frozen since 2022, even as comparable as CST schemes expanded. Focusing on segregation, Rajasthan in March 2026 and an expanded Gujarat Disturbed Areas Act now restrict property transactions in areas designated disturbed on grounds of demographic imbalance, consistent with a February 2026 study of 1.5 million neighborhoods finding markedly worse public service access in these segregated Muslim areas. So beyond the budgetary and scheme data that the State Party has already provided in the report, what indicators do the authorities use to measure an actual reduction in segregation or in discriminatory practice, in fact? And does the State Party plan to commission or publish outcome evaluations involving also civil society and communities? affected. Can the delegation respond to this Rajasthan and Gujarat Disturbed Areas Act legislation restricting property transactions on grounds of demographic imbalance and those independent findings of residential segregation of Muslims? And what explains the discontinuation of the Maulana Azad Fellowship and the scholarship freeze since 2022? Does the state party intend to restore this welfare infrastructure? I'm now passing to the situation of Dalits and focusing on untouchability, exploitative labor, child labor, and segregation. The committee takes note of the legal framework, including ICDS priority for SCST villages, the Manual Scavengers Act, general women's safety measures, though data remain undisaggregated for Dalit women and girls. Despite the 2013 Act, at least 1,289 people have died cleaning sewers and septic tanks since 1993, 52 in 2024 alone, with no recorded NCRB prosecution. Of 18.4 million acknowledged bonded laborers, under 2% have been rehabilitated since 1978. The rehabilitation budget was cut 75% in 2 years. 63% of rescued workers surveyed were Dalits. According to reports before the committee, in June 2026, police in Muzaffarpur, and sorry again for my pronunciation, Uttar Pradesh, rescued 12 workers, some minors, from a disposable leaf bowl and paper plate factory. They were lured from railway stations and bus stands with false promises of work and stripped of documents. They had been confined for months, some over a year, forced to work from before dawn until midnight, fed roti made of cattle feed, and beaten with iron rods, wipes, and dogs. One worker allegedly died under torture in late 2027 and his body disposed of. Charges were registered under the Bharatiya Nyaya Sanhita, the Bonded Labor System Act 1976, and the Child Labor Prohibition and Regulation Act, but the case came to light only because a worker scaled the factory wall and reached a police station, so not through state labor inspection or other enforcement mechanism. A 2021 UNDP report ranked scheduled tribes India's poorest group, 50.6% in multidimensional poverty, followed by scheduled castes, 33.3%. Caste-based exclusion persists in domestic work, including Urban Company's 2025 InstaMate service, later renamed after backlash over denial also of washrooms and water. Maharashtra's SC sugarcane cutters report coercion into hysterectomies in Andhra Pradesh, Karnataka, and Bihar, have reportedly also excluded Dalit communities from relief and recovery, reflecting the absence of course, what is required under the convention, caste-sensitive disaster governance and intersectionality. These patterns extend to disaster response. So floods in Andhra Pradesh, Karnataka, Bihar, and other regions have reportedly excluded Dalit communities from relief, compensation, housing, and recovery programs, deepening existing inequalities and pointing to the absence of this approach required under the convention. Please clarify and provide examples which anti-discrimination law is covering caste in private employment, whether the 2025 labor codes address caste-based discrimination. Given zero recorded NCRB prosecutions under the Manual Scavengers Act since 2013, against background of this high number of deaths, what is the state party doing to eliminate the practice rather than, just criminalize it only, in law? Could the delegation provide information on measures to end bound labor, including through work inspections? With fewer than 2% of bonded laborers rehabilitated since 1978 and the rehabilitation budget cut, does the state party consider it's current of the problem? What updated disaggregate data exists on the incidence of untouchability practices and segregation of Dalits in housing, education, and public spaces? And what outcome measures are distinct from, scheme description? I know it was briefly discussed yesterday, but it would be good to clarify whether the data shared on gender and sexual violence were caste disaggregated, given that the figures in the report are population-wide. So finally, what measures are taken to ensure that Dalit and other marginalized communities are not excluded from flood relief, compensation, and recovery programs? I'm now passing to participation and representation in public and political life. I know it was briefly discussed yesterday, but we have to come back to this point to understand better the situation in the country. The report provides reserved constituency figures, employment reservation percentages, and Group AC civil service representation data comparing 1965 and 2019, but confirms reservation has not been extended to higher judiciary appointments, which remain a matter of collegium discretion. Yesterday, the committee raised our concerns on the West Bengal special intensive revision of electoral laws through the citizenship discussion and the reported removal of up to 9 million names ahead of the April 2026 elections, and will not repeat these questions here, though I look forward to the delegation's response in due course. I would like to use the time remaining to focus on representation within the judiciary, the civil service, and the university. In March 2026, the government informed Parliament that of 849 High Court judges appointed since 2018, only 33 belong, so 3.9%, belong to the scheduled caste category, while also acknowledging that caste-wise data on serving justice is not maintained centrally, which of course raises an issue of transparency and accountability.
Could the speaker kindly slow down for the interpreters, please?
Based on my research, only 2 persons from the scheduled caste community have served as Chief Justice of India, Justice Balakrishnan and Justice Gavai. Government data further show that scheduled castes make up only 2.42% of serving administrative service officers, 3.6% of police services officers, and 4.39% of foreign officers, well below the constitutionally mandated 15% reservation, pointing to persistent barriers in senior decision-making positions and other positions. Academics and researchers from scheduled castes, and more broadly those working on caste and racial discrimination, are reportedly underrepresented in recruitment to universities and the research institutions, limiting, of course, both career advancement, but also the depth of independent scholarship available to inform policy in this area. What is the explanation for not extending reservation to appointments in the higher judiciary? And is the state party considering alternative measures to improve diversity on the bench, including addressing the absence of centrally maintained caste date on serving judges? What is being done to close the gap between, the 15% constitutional reservation for scheduled caste and their actual representation in civil service positions and the university? And also, could the delegation provide updated data on SC and ST representation specifically within law enforcement agencies as distinct from civil service-wide figures? I now pass to right to health and education. The report describes the NHM-NUHM architecture, Janani Shisu Suraksa Karyakram, Mission Intradanus, and nutrition programs in universal terms, without scheduled caste and tribes disaggregated outcome data. So this is the same gap the committee raised in 2007. NFHS 5 data fill part of that gap, and I know that it was raised, so I'm really looking forward to hear more about this data. Anemia affects 59.2% of scheduled caste women aged 15 to 49 against a national average of 57% and 69.5% of scheduled caste children aged 6 to 59 months. Under 5 mortality among scheduled castes stands at 49 per 1,000 live births against 33 among communities outside the SC/ST categories. Neonatal mortality is 29 against 20. So comprehensive caste disaggregated data on maternal mortality on the mental health impacts also of caste discrimination remain unavailable. On education, spending and gross enrollment ratios have risen, but no incidence data exists on classroom segregation, nor independent monitoring of the 25% private school quota under Section 12, Paragraph 1C RTE. On Muslim educational institutions specifically, it was reported that since October 2024, the NCPCR, the National Commission for Protection of Children's Rights, has recommended states halt madrasa funding. Assam has converted over 1,200 government aided madrasas to general schools. Uttarakhand sealed over 170 madrasas in April 2025, and Jammu and Kashmir has seized over 2070 schools linked to a banned organization. For Adivasi children, enrollment is comparatively high, 67.7%, but primary level dropout is also high, 70.9%, with negligible use of Adivasi language as a medium of instruction. So given these disparities in anemia and under 5 neonatal mortality among scheduled castes, what measures beyond universal schemes specifically target these gaps? And will the state party publish comprehensive caste disaggregated data on maternal mortality, but also the mental health impacts of caste discrimination? What independent monitoring exists of the 25% private school quota? And can the delegation clarify the legal basis and safeguards for the funding, conversion, closure measures affecting madrasas since 2024? What accounts for this high primary level dropout among Adivasi children, despite comparatively high enrollment? And does the state party plan to expand instruction in Adivasi languages? And I finish my part with the issue of human rights defenders. The report describes a general protective framework, the RTI Act 205, the Whistleblowers Protection Act, and the National Human Rights Commission 24/7, Human Rights Defender Complaint Focal Point, toll-free numbers, a small number of monetary relief recommendations over the last 4 years, but nothing specific to defenders working on racial, caste-based, tribal discrimination issues, which is what the list of themes asked about. Civil society and the list of issues. Civil society reports that civic space for organizations documenting racial discrimination has been significantly constricted through the Foreign Contribution Regulation Act 2010 as amended in 2020. The Prevention of Money Laundering Act in 2002 and the Unlawful Activities Prevention Act in 1967 used to cancel foreign funding licenses and to investigate or prosecute staff at organizations monitoring discrimination. But also in the Bhima Koregan Elgar Parisat case, 16 lawyers, academics, and defenders were arrested under anti-terror legislation, including scheduled caste scholar Anand Teltunde, Dalit rights activist Sudhir Dawale, and Father Stan Swami, an 84-year-old Jesuit priest who had spent decades defending Adivasi land rights and who died in judicial custody in July 2021 after repeated denial of bail and medical care, a case the UN Working Group on Arbitrary Detention found arbitrary. In Bashtar, Adivasi defenders, including Sanita Potam of the Mulwasi Bajau Manch, designated unlawful in October 2024, report a pattern of rearrest on new charges timed to prevent release even after acquittal in most prior cases. Co-founder Raghu Midiami remains in custody under the UAPA despite the ban on the organization having lapsed. A similar pattern of repeated prosecution on minor charges has been reported against land and river right defenders in Assam and Arunachal Pradesh opposing displacement by infrastructure projects. What monitoring mechanisms exist to identify and address abusive application of the FCRA, the Prevention of Money Laundering Act, and the UAPA against organizations and individuals working on caste, race, or tribal rights issues? What data does the state party maintain on incidents of harassment, intimidation, reprisal against defenders working specifically on racial, caste-based, or tribal rights issues? And finally, what is the government's vision for the role of civil society in monitoring and addressing racial and caste-based discrimination in India? And will the state party consider making a public statement to protect defenders from and prevent abuse and harassment by also private actors? What are the measures taken to address similar concerns expressed, as we know, by other human rights mechanisms, such as special rapporteurs of the Human Rights Council and also the Human Rights Committee? And I will stop here. I still have 2 minutes and 30. Thank you, Mr. Chair, and thank you in advance for your answers.
Thank you very much for saving us some time. And I will immediately turn to the head of the delegation and give the floor for 20 minutes to answer these questions raised in this first team segment. Thank you.
Thank you, Mr. Chair. To begin, I will hand over the floor to Ms. Mona Kandahar, Additional Secretary in the Ministry of Social Justice and Empowerment.
Mr. Chair, I would like to begin with bringing to the notice of esteemed committee the recent number of candidates selected for the highest level of civil service examination. In total, there were 958 candidates were selected, out of which 158 belonged to SC, which is 16.79%, a little above than the mandated reservation. There were 73 ST candidates, which is 7.62%, again a little more than the mandated percentage. Other backward caste candidates were 306 and economically weaker section 104. And general category candidates were only 317. Now I would like to bring to the notice of the esteemed committee the elaborate support provided to scheduled caste and scheduled tribe, right from high school, right from secondary school to high school, to higher education, and even to overseas education. They are provided with the free coaching to appear in this kind of competitive examination. I have an elaborated data. However, to save the time, I will just illustrate a few of them. So far as secondary school is concerned, in 2024-25, 2.16 million students, SC students, were provided with 4.6 billion of scholarship support. In case of higher secondary school education in 24-25, 4.8 million SC students were provided with rupees 55 billion of scholarships. Going forward, I have already mentioned that enrollment in higher education for both SC and ST have improved substantially. And in fact, in some categories, they are the ratio is even higher than general categories. There are data related to scholarships provided for higher education as well as overseas education. And that I can submit later on within that 2 days that we are getting. So that is related to health. So far, that is related to education. I will come back for health-related outcomes. For in case of housing, I want to mention that government has a very elaborate and flagship scheme for providing housing both in urban and rural area. And that 60% of housing allotment is reserved for scheduled caste and scheduled tribes till they are saturated, and only after they are saturated, more housing are provided for the other categories. So this is for housing and education. For health, I will revert very soon. Thank you.
Thank you, ma'am. May I give the floor to Solicitor General Tushar Mehta?
Firstly, ma'am, on the question of segregation of a particular religious group, I must point out that there is a law first in Gujarat since 1991. And there is a bill, not a law, in Rajasthan. Let me make it very clear that it is not for the purpose of segregating population based on religious lines. There are certain areas earmarked by the government based upon statistics and based upon the figures available, where it is found that some of the houses, some of the residential units are being sold under duress by A against B. There is no prohibition against sale in those areas where there is an apprehension that somebody can pressurize the owner of the house to sell it to someone at a lesser price or a distressed price. There is a mechanism or a regulation that the district magistrate, who is a neutral, independent authority under the Act, will examine both the proposed seller and proposed buyer, and he will come to a conclusion that this is a voluntary sale and not a distress sale. That's the regulation. There is no prohibition. That's somehow a wrong narrative which has come in the public domain. Now, so far as human rights defenders are concerned, it is the position of the government that human rights defenders are to be defended at any cost. Civil society organizations are actively working with the government. See, we have a huge country and there cannot be any dispute about it. There are thousands of civil society organizations and thousands of public spirited people, civil society organizations, human rights defenders. But you will notice that only handful of few are come in the public narrative. Therefore, I would like to say that India is committed to ensuring an open and safe environment for civil society organizations and people engaged in promotion and protection of human rights. India has always condemned any harassment, any intimidation, any coercion, smear campaigns, and violent attacks against any civil society organizations. The Right to Information Act enables them to find out where the problem lies, and there are statutory remedies under the Constitution and under various laws which protects them. The NHRC, you have already taken note of that there is a separate mechanism provided for that. Ma'am, you referred to Bhima Koregaon. This is one of the issues being frequently coming up at various forums. I must make it very clear that Bhima Koregaon, I'm not sure whether they are public right defenders, or even if presuming them to be so, there is material evidence on record which has been frequently and repeatedly examined by various levels of court, right from the trial court to the High Court to the Supreme Court. Since the matters are pending, it may not be appropriate for me to go into the details, but after having examined the evidence dispassionately by an independent judiciary, various orders are passed and they are not in favor of those who are accused of that offense. So they are not facing any investigation or any action because they are human rights defenders, but because they are found to be guilty of some law of the land. So far as PMLA is concerned, we have a very robust mechanism of prevention of money laundering. But to my knowledge, there is no human rights defender who is subjected to PMLA proceedings. I can collect the details, and if necessary, we will place it before the. It's essentially for those who amass illegal wealth and try to launder it. But my statement is very clear. Harassment of human rights defenders or civil society organization is completely unacceptable to the country. Even by the private individuals, the country does not support, and there is an inbuilt and most effective statutory mechanism which takes care of any private harassment also. There are instances, but I need not cite that. But there are several civil society organizations which work hand in hand along with the government in uh, implementing several welfare schemes, and the government is virtually working with them, except few individuals cases which are being cropped up here or there. For will not go into that. Thank you.
Thank you, sir. Other issues आप बाद में करें. SIR. May I now hand the floor back? Would you like to go, or Madam Nishta? Yeah, Madam Nishta from Minister. Yeah.
For that, if you your 2.5 minutes, you can use it if you need more clarification while the information is provided. Thank you. Yes, please.
Thank you, Chair, for making the dialogue more interactive as it needs to be. So yes, I thank you for the answers. What I find, I think that what we are missing here is these allegations on, harassment by private actors. And, sometimes we see it a lot, and we see it in many states. Sometimes it's not that, sometimes, the system is there, the mechanism is there, but it's not always function efficient. And it's a matter also of an environment that goes, the central government does not always probably, have the monitoring tools to see what's happening at local level. So I welcome the statement on human rights defenders by the head of the delegation, because it's very important. But I will continue to insist that this kind of statements, again, because you have this beautiful, a very big country, and with so many human rights defenders, needs to reach every single small part of your beautiful country, because indeed you have many organizations, and we know that not all organizations are the same. And as you know, human rights defenders are also supposed to be, like putting the government and the authorities in question the government, not always be very nice with the government. This is what, of course, it's the democratic space. This is what is expected, and this is also, and their role is very important. So I think that it's important to keep this in mind and make sure that this message that the statement that you just shared reaches, the society. I now say that I exhausted my time, and I stop here. Thank you.
Thank you.
Thank you, Madam Mona. Would you like to, or what Madam Nishta would like to take? Okay, Madam Nishta.
Little time to elaborate upon gender-based violence, which was raised yesterday, and today also Madam mentioned about it. So, Mr. Chair and esteemed members, protection of women, including Dalit and tribal women, from gender-based violence remains a matter of highest priority of Government of India. It is reflected in a comprehensive, multi-pronged approach spanning legislation, technology, and institutional capacity. In this regard, women help desks have been established in police stations nationwide to make reporting more accessible and gender sensitive. They are backed by the Pan-India Emergency Response System 112 and a national database on sexual offenders for tracking repeat offenders has also been established. The Criminal Codes, updated in 2023, places offenses against women and children in its very first substantive chapter, mandate audio-video recording of victim statement, and guarantees free medical treatment for all the victims at all the hospitals. Protections for tribal and Dalit women specifically rest on the SC/ST Prevention of Atrocities Act is reinforced by Women Help Desk, that is e-Saksh platform. I can translate it, e-evidence in English. Expanded forensic and DNA capacity, and 775 fast-track special courts, including POCSO courts, are also established to deal with these matters. In terms of further figures, on capacity building, 35,306 investigation officers, prosecutor, medical officers have been trained through the Bureau of Police Research and Development and National Forensic Science University, alongside 37,978 police officers trained specifically on DNA and forensic evidence handling. 8,020 sexual assault evidence collection kits have been distributed to provinces and union territories to strengthen scientific evidence collection at the point of first response. On victim support, 864 one-stop centers are now operational nationwide, having assisted over 2025, while the in 35 provinces and union territories. These figures reflect not intent alone, but measurable, sustained investment in reach and delivery to each of the citizen of the country. Thank you.
Thank you. May I hand over the floor to Ms. Mona?
I'll begin with adding a few points to what my colleague has just mentioned. I would like to mention that we do maintain segregated data of gender and sexual violence for SC and ST women, and I gave those data yesterday. I would also like to mention that we have a national helpline against atrocities, and it provides threefold protection. It provides a rescue, immediate rescue, and for that we have integrated with every police station. Secondly, it also takes care of mental health issues and counseling, and for that we have integrated with NIMHANS. Thirdly, it takes care of rehabilitation and tracking. So that is what I wanted to say here. Now I will brief about the health outcomes. I would like to begin by mentioning that as per National Family Health Survey, fifth National Family Health Survey, the infant mortality among the scheduled caste population declined from 45.2% in 2015 to 40.7% in 2019. Similarly, the under 5 mortality rate decreased from 55.8% to 48.9% during the same period. I would also like to mention that so far as rural areas are concerned, if we look at the data, the neonatal mortality among scheduled caste is 31.4, among scheduled tribe it is 29.7, and others it is 22.4. So the point I want to bring to the notice of esteemed committee is, we are seeing a declining trend among in this health outcomes for SCs and STs, but we are well seized of the fact that we need to catch up fast. They need to catch up fast with the general population, and that also we are seeing that gap is getting narrowed down. I would also like to mention that our approach to right to health is based on universal and non-discriminatory access, supplemented by targeted intervention. So far as general health measures are concerned, we have an elaborate framework of public health institutions right from village level, and that is specifically to reach out to the last mile categories of SCs and STs. We also have mobile health ones. This is for preventive and public health related services. I would also like to mention or add to the educational data that I had provided. So far as higher education is concerned, sorry, I'll come to that later on.
Perhaps I will come back to you and
Yeah.
give the floor now to Mr. Rao from Ministry of Minority Affairs.
A question had been raised on the Sachar committee, and recommended minority welfare infrastructure has been rolled back. In this regard, I would like to highlight the following points so that the issue is cleared. So the government had accepted 72 out of the 76 recommendations of the Sachar committee and had clubbed the similar nature of recommendations, and had taken 43 decisions in the following focus areas. For education, we had 15 decisions. These were clubbed. Similarly, for skill development of minorities, 2 decisions. Access to credit, 6 decisions. Special development initiatives, 2 decisions. Measures for affirmative actions, 4 decisions, such as setting up of expert group on equal opportunities and diversity index, etc. protection and management of work properties, and miscellaneous others. The responsibility for implementation of these decisions were given to Ministry of Minority Affairs and the concerned ministries and departments whereby schemes, programs were introduced to improve socio-economic conditions of the Muslims. The Ministry of Minority Affairs has adopted multi-pronged strategy by way of implementation of various schemes in pursuance of the Sachar Committee report, which aim at the socio-economic development of the notified minority communities, including employability through education empowerment, employment-oriented skill development, infrastructure supports under different schemes such as PM Vikas, PM Jan Vikas Karyakram. These schemes of the government have enabled the minority communities in securing employment in various organizations, including private sectors. Now, coming to the question of the Maulana Azad Fellowship being discontinued, it is submitted that the Minority Affairs Ministry implemented this Maulana Azad Fellowship scheme to provide 5-year fellowships in the form of financial assistance to students from 6 minority communities, namely the Buddhist, Christians, Jains, Muslims, Parsis, and Sikhs. And this was to pursue the MPhil and the PhD programs. The scheme had been implemented in line with the Junior Research Fellowship and Senior Research Fellowship of UGC, the University Grants Commission. The scheme was launched in 2009-10. Now, it was observed that the University Grants Commission and CSIR fellowship schemes are open for candidates of all social categories and communities, including minorities. Further, students from minority communities are also covered under the national fellowship schemes for scheduled caste and OBCs implemented by the Ministry of Social Justice and Empowerment. So in view of this overlap among the aforesaid schemes, MANF has been discontinued from 2022-23. However, benefits of existing already enrolled students prior to discontinuation are being liquidated and will continue till 2030-31. As regards the scholarship schemes that have been running for the minorities, there are 3 schemes that are being run for the minorities. One is pre-matric, that is secondary school, up till the secondary school. So far, 71.1 million students have benefited, and amounts have been released to the extent of 122.91 billion. Post-matric, that is post-secondary, the education has been covered for 10.5 million students, and 52.21 billion has been spent there. For merits cum men's scholarship, we have given benefits to 1.4 million, and 35.5 billion has been spent there and there. So a total of 83 million has been students have benefited out of 200, and amount of 210 billion has been spent thereon. The scholarships have not been discontinued as such, but there have been some allegations, and that are being investigated, and these are, until these investigations are completed, this scholarship cannot be started off as of now.
Thank you. We are really tight on time. We have 3 minutes. I give the floor to Ms. Mona, and then if you have time, there are a few other questions, or we might require a few more minutes. Thank you.
Touch upon the higher education part. We have reservation in public higher
can
education.
you do the manual scavenging? I
Yeah,
think that
I'll
was
do it.
okay. Thank you.
Seconds. There is a reservation for SCs and STs in private higher education institutions, and so far as public higher education institutions, and so far as private higher education institutions are concerned, they are given scholarship. And I'll just mention that in 24-25, 4,143 SC students received 2.1 billion of scholarships. So that is related to how we manage that in private institutions also they get this kind of support. Now I'll come to manual scavenging part. Yeah.
Should we come back to you later, perhaps?
I'll just start. Now, manual scavenging, as specifically defined under the 2013 legislation, is prohibited. Earlier surveys identified 58,098 eligible manual scavengers who were extended rehabilitation benefits. Pursuant to directions from Supreme Court of Fresh, nationwide survey was subsequently undertaken, and the latest available information has not reported instances of manual scavenging as legally defined. This should not, however, be confused with the separate and serious problem of hazardous cleaning of sewers and septic tanks, which is itself prohibited by the same law. The government recognizes that fatalities have unfortunately continued to occur where safety requirement and prescribed protocol have not been followed. India is addressing this challenge through progressive mechanization under the National Action for Mechanized Sanitation Ecosystem Namaste. As of 31st December 2025, 90,915 sewer and septic tank workers had been profiled. The program provided training, personal protection equipment, health and social security coverage, mechanized equipment, and livelihood support, along with strengthened emergency response sanitation units. Thank you.
Mr. Chair, I know we had a few more questions to answer, but perhaps in the follow-up last. In the follow-up. Thank you.
Thank you. Thank you very much. I will immediately go for the next phase of our discussions. The floor would be open to follow-up questions by the country task force as well as all the members. I would kindly ask to formulate your questions briefly and clearly so that, because we have only 15 minutes for this. The floor is open. Madam Stavrinaki, you have the floor.
Thank you, Chair. I will be brief. First of all, I would kindly ask the delegation to submit the data. I mean, what it would be very, very useful for the committee is not only to have, you know, absolute numbers and figures on how many, it's important to know how many people have benefited for these measures, but it's also important to understand what is the scale in relation to, you know, the populations and the people recognized as STs. So it's important to show that the state authorities have a clear plan, which is budgeted, time-bound, and clear in their goals. Second question I would like to also raise, to the point that I would like to raise, is to explain our approach. You know that the Supreme Court has recognized already and deepened the idea of discrimination by recognizing indirect discrimination. So when we ask these questions about, you know, for instance, Rajasthan, etc., we are asking whether the authorities have taken into consideration that these measures might have a disproportionate effect indirectly to certain, you know, groups within the larger groups of SCs, STs. So this is why we're asking these questions. So maybe even if, you know, the intentions are good, finally what, you know, and they're not discriminatory at face value, finally the way they're applied may discriminate or may have a negative effect on a specific population. The same with the data from the police. I really appreciate the efforts. They are very important, and I realize, you know, the progress that has been made. It would be good to know what do they represent in practice. So in terms of, you know, percentage of a population affected, because we know that it's an ongoing process, reporting of violence, as we all know, and especially gender-based violence. And also, it would be important as well to know what happened with these cases, because I understand that the police has adopted protocols, but what happened after this? Have they been convicted? Do we have a percentage? You know, we would like to know more about the life cycle of these cases, and finally how this, you know, outcomes, if they empower women to exactly to report new cases. So I'll stop here to leave the opportunity to colleagues. Thank you, Chair, and thank you in advance for your responses.
Thank you, Madam Stavrinaki. Madam Chung, would you like to take the floor? No. Madam Shepherd, would you like to take the floor?
presentation following this now, so I will reserve my questions for then.
Thank you. Then I have Mr. Senor Vicente Vasquez on my list, and then Madame El-Misnad.
Muchísimas gracias.
Thank you very much, Chair. First, I would like to say that I'm an Indigenous person from the Zapoteca people. So I am pleased that India is considering all of the Indigenous people. I have millions of brothers and sisters in your country. That being said, yesterday I didn't have the opportunity to ask a few questions, so I would just like to focus on one particular question. We've received a number of reports on the development of the extractive industry and energy projects, including mining projects and those for dioxide. I'm sorry for saying perhaps my pronunciation in Odisha, carbon extraction and dams in Arunachal Pradesh, built in lands that were traditionally occupied by indigenous people and tribal peoples. So I'd like to ask if you could set out the mechanisms that have been established to consult and obtain consent from indigenous and tribal peoples before endorsing such projects. And what measures for mitigation have you adopted to protect sacred sites, cultural heritage, and the ways of life of indigenous and tribal peoples? And on these questions, I would kindly draw your attention to the new guidelines on the right to free, prior informed consent in the context of business enterprises that were drafted by the Working Group on Human Rights and Business Enterprises that was published in June of this year, 2026. Thank you very much.
Thank you, Senor Vicente Vasquez. Madame El-Misnad.
Thank you, Chair, and good morning, everyone. I will just continue on what the country rapporteur has started to talk about education. And the state party explain how much money, how much scholarship they are given. But the issue is not the number, the budget. The issue is to understand really the education opportunities for minorities. We need more information than that. Like, what is the ratio of enrollment of students of this minority? I mean, it looks good in the country report, but according to some information, the minority children are really, enrollment rate is really low at all levels. I mean, I don't know if the information I have is correct or not, but it's like between 20 and 18 from pre-primary to primary to secondary. Muslim student at the university, like 20% for male, 11% for female. So first, what is the enrollment ratio for all of this group in the education system, and what is their percentage within the total population of students in the country? I know that minority education in India face a lot of problem, economic problem, cultural problem, language problem. But I think without this information, we will not be able really to understand the situation of education of minorities. Complete or general numbers doesn't show the picture. The money spent, the scholarship given does not give a clear picture of how many children in this community are being benefited from all of this. Thank you.
Oh, thank you, Monsieur Diaby.
Monsieur le Président.
Chair, I'd like to quickly go back to the question on hate speech. This question was raised and the delegation provided some replies, but we have heard reports that sometimes those who are behind hate speech, for example, political leaders or high-ranking officials, that engage in such hate speech or xenophobic attitudes vis-a-vis ethno-religious minorities. So what measures are considered by the authorities to combat this kind of scourge, especially when it's coming from official people, leaders of political parties, or highly placed individuals within the state institution? Have there been any investigations into such incidents or any decisions that have been handed down, any sentences on this kind of offence? Thank you.
See, Monsieur Diaby, the floor is open. Yes. Madame Stavrinaki.
Thank you, Chair. Since I don't see any other colleague asking for the floor, I just would like to take the opportunity, and since we were talking about education, to express my sadness about, the recent events, and especially the young people who lost their lives and committed suicide due, to the university, the admission issues. So it's not, I just wanted to say, even though it's not directly connected to the convention, I just, wanted to share my condolences, and also just, make a small statement to every young person who, tries to study and improve their lives, that there is always a way, and just, share all my my good thoughts with their families and the future generations that are the power of this country. And thank you, Mr. Chair.
Thank you, Madame Stavrinaki. The floor is still open. And I don't see anyone asking for the floor. Okay, we have 5 minutes extra, and I will give the floor to the delegation now for 25 minutes. But if in the meantime, any of the members would like to intervene for further clarification on a particular issue that has been explained to us, then we have this 5 minutes to be used. Thank you. You have the floor, sir, for 25 minutes.
Thank you. Thank you, Mr. Chair. I'm very happy to see a very dialogue and actually a conversation. Happy to have that. That actually gives an opportunity also to clarify how we look at it. Before I give the floor, let me just make just a comment. Some of the members mentioned some general statements which we will speak about it later. Not all of it is accurate, and I'm happy the member state that we don't know if it's accurate. Look, you receive information from various sources. India is a big country. Please do due diligence to check that information. For example, a comment that education opportunities for minorities is very difficult. They face a lot of difficulties. I would hesitate to say that. If you ask people, yes, there are people who are poor, people who have difficulties, but let's say primary education is absolutely mandatory till 14. Free and mandatory. And it's very difficult for an Indian to say that there are difficulties. Yes, there are difficulties. They're poor, they're doing very other things, but to say that there's discrimination because they are unable to face. In fact, we are very pride ourselves on the very high level of net enrollment ratio, for example, at primary level. But let me not get more into detail on that. Let me hand over the floor now to Madam Mona. You will talk on some of these issues. Thank you.
I would like to begin with my response to the scale part that has been raised by one of the esteemed members. The scale vis-a-vis the benefits provided. I would like to mention that government is adopting saturation approach so far as welfare programs for SCs and STs are concerned. For example, the community-related welfare program that has been rolled out for SCs and STs, which are the flagship programs of the government, where the socio-economic indicators are for SCs and STs are focused on, including for health, education, and other important criteria. So there the saturation approach has been adopted, wherein the criteria that has been selected for extending these benefits, they are 100% surveyed. So we identify the quantum of work that is required to be done, and a systematic interventions are carried out to ensure that these communities are, they are developed to the socioeconomic indicators identified for this program. So there is a saturation approach. I have already mentioned that so far as housing program is concerned, there is a saturation approach for SCs and STs. Yesterday, I also talked about the development action plan, both for SC and ST, which is a government-wide across the ministry approach. And all this ministry, which is 37 plus ministries, and that includes the sectors like disaster management. And they all need to focus especially on SCs and STs for each of their interventions, and they are monitored very closely. So I would also like to talk about the independent monitoring and evaluation agencies. Chairman, sir, we have a National Commission on Scheduled Caste, we have National Commission on Scheduled Tribe, and other caste as well. Now, National Commission for Scheduled Caste has a constitutional mandate to monitor safeguards, investigate complaints concerning deprivation of rights, and advise on socioeconomic development and protection. So it has both, it functions in both the realms of enforcement as well as advisory. Access to commission has also been substantially strengthened through its e-grievance management portal, which enables online filing, automatic routing of complaints, and issuance of notices and reminders and real-time tracking by the complainant. These mechanisms produce concrete outcome. In 2024-25, the Commission addressed a substantial range of socio-economic grievances, including 1,975 land-related matters, which are generally tricky and complicated. Its provincial reviews of Kerala and Punjab state examined inter alia the utilization of funds intended for scheduled caste, and while reviewing public sector banks, the Commission identified shortfalls in coverage of scheduled caste beneficiaries under government schemes and direct corrective actions. So far as independent evaluation of welfare programs are concerned, we have a very elaborate system. It is the independent evaluation carried out within the system as well as outside the system. Within the system, we have 3 tiers of government: union government, provincial government, and local self-government. Local self-government again has 3 tiers: village, block, and district. So generally the plans are prepared at village level, but they are independently evaluated by the provincial government and also by union government. That is within the system. Now, if we talk about outside the system, the in-depth evaluation is made by Niti Aayog, which has its own set of experts. This kind of evaluations are also given to reputed national institutions and even educational institutions. And all the programs are evaluated independently, and the further course correction and other things are carried out through evidence-based planning and implementation. Thank you.
Thank you. May I briefly give the floor to Mr. Roy for just a clarification on some numbers? Thank you. Microphone, please.
Chair, there was a query regarding the numbers of specific community-wise on the scholarship part. So I have the numbers and I'll just share it with you. For the scholarship that was given for the secondary and pre-secondary scholarship, so this is 4 billion out of the total scholarship of 6 billion. 4 billion went to Muslims. Similarly, for the post-secondary, the scholarship amount, which was the scholarship that was granted to 844,000 people, 626,000 were given to Muslims for the 5 years, 2021 to 25-26. Again, for merit cum means scholarship, this amount that was, the numbers that were covered were 146,000 Muslims for the 5 years that we're talking.
Thank you. May I now hand over the floor to Solicitor General?
Thank you. I would first like to deal with or answer the issues regarding the closure of madrasas in Assam. Look, ma'am, we have to go by the constitutional mandate. Article 28 of our constitution prohibits state funding to any religious education, not only one particular religion, to every religion. There were approximately 1,200 madrasas imparting only theological education. So they are not closed, they are converted into the regular schools where all subjects will be taught, not theological subjects. This is done through an act of a competent legislature. It's not a government or executive action, because every section of the society is represented in the legislature, and we have Madrasa Education Provincialization Act. So that is the constitutional position. So far as right to education is concerned, I would like to add to His Excellency the Ambassador's point that right to education is elevated in India to the level of a fundamental right. It is a fundamental right under Article 21. A new article is added, Article 21A. A new act is enacted where it is free. And we should not forget that our first education minister was Maulana Azad, the Muslim himself. And thereafter also, there have been several instances where Muslims have been at the helm of affairs in the education ministry. Now, one more question which I would like to clarify, that is concerning, ma'am, you said that Father Stan Swami died without medical treatment. Now, I must clarify, he was 84-year-old. I'm not going into the evidence against him because that was examined several times by several courts at several levels. But he was hospitalized in the hospital of his choice, that is Holy Family Hospital in Mumbai. He was under medical supervision and he died of age-related issues. It was not without then. Now, coming to the question of FCRA. Now, let me point this out because this is the vital question. The India wishes to place on record at the outset that regulation of foreign financial flow into public and political spaces is an accepted and well-established feature of governance in democracies around the world. It's not India specific. India's framework is neither exceptional nor punitive or restrictive in nature. It's only regulatory in nature. For those NGOs seeking foreign funding, the amendment merely seeks to bring a regulatory framework. This is proportionate compliance framework, not a barrier to the entry of foreign funding. This regulation framework applies across the board without any discrimination, targeting one religion, one caste, or one community. India's regulatory framework for foreign contribution is not new. It's not being introduced for the first time. The first Foreign Contribution Regulation Act was in 1976. Thereafter, it was modernized in 2010. Thereafter, it was amended in 2016, 2018, and 2020 as the need and the experience was gathered. The 2026 bill, which is still in the parliament, and therefore I think it may not be appropriate for me to dwell much on that, but it represents the next incremental step in the same continuum aimed at greater transparency, proper regulation, and clearer and predictable rules for all stakeholders across all religion, caste, communities, etc. Now, India's approach is consistent with and indeed follows established international practice. The United States has regulated foreign influence in public life through Foreign Agent Registration Act since 1938, the Foreign Account Tax Compliance Act 2010. Australia, United Kingdom, European Union, everyone have their own legislative framework to regulate as nations any inflow of foreign funding. Now, but India remains committed to vibrant, rule-based civil society sector operating with transparency and accountability. I must point out one factor, and that may be at the outset, that we have 3 million non-governmental organizations. And please note this very carefully. 3 million non-governmental organizations. Most of them are working from the aid or the financial support given from within the country. Only 14,450 are getting foreign funding, and they are registered under the FCRA. Rest of them, that is the overwhelming majority of the civil society or human rights defenders, they are funded and supported by the people of India. So it's not something which is disproportionate by any standard. Next, I would answer the question of the honorable member about the Special Intensive Revision, SIR. Ma'am, SIR is an electoral roll exercise conducted by an independent and constitutionally mandated and constitutionally framed Election Commission of India under Article 324 of the Constitution. Government of India is not doing it. This process aims to ensure that every eligible citizen is included, is not left out of his right to franchise, and no ineligible person remains in the voters list. So this is a cleansing process of democracy. The governing criteria, that is citizenship, age, ordinary residence, and statutory disqualification, apply uniformly without distinction to religion, caste, creed, or any other criteria which can discriminate one citizen from the other. SIR is neither novel nor directed at a community or being done for the first time. The Election Commission of India, as I said, it's a constitutional body and not a part of the executive. It has conducted 8 intensive revisions between 1951 and 2004. This 25-26 phase covered 12 different provinces, which we say states in our constitution. And it took within its sweep 510 million electors. Their last intensive revision happened in 2002-2003. Migration, unreported death, multiple registrations, etc. These were the reasons why a renewed verification through this intensive revision was felt necessary by the Election Commission. But there are safeguards operate throughout the process to ensure that no eligible voter is excluded. On 27th of May 2026, the Supreme Court upheld all arguments were made by all sides, and after an extensive debate, the Honorable Supreme Court of India has upheld the SIR in Bihar as lawful and proportionate. Supreme Court held that Commission may make a limited inquiry into citizenship only for the purpose of electoral eligibility, which will not decide the citizenship of any individual. So far as West Bengal is concerned, I would like to inform, and I will be very happy to inform, that with the agreement and consent of the Government of India, since I happen to appear for the Government of India, the Honorable Supreme Court had requested 800 judicial officers to be tasked with this process, not officers under the executive. And judicial officers were to be selected by none other than the Chief Justice of the High Court of Calcutta. And they conducted this entire process. And if there is any grievance by any of the electoral, either for inclusion of someone or his own exclusion, there is a remedy provided by way of tribunals, which are headed by former judges of the High Court, and few of them are former Chief Justices of the High Court. So it's a religious neutral, regular process for weeding out those who may have died, migrated, maybe at 2 different provinces, etc. Now, at the end, I'm really grateful for the Honorable Rapporteur to categorically mention that it is the personal view of the Honorable Member regarding the some issues going on with regard to the students, and the government of India shares any death, etc., needs to be looked into, and government of India is seriously concerned about redressing grievances of the children, and government has constituted a very high level committee consisting of people of undisputed integrity and domain expertise and neutrality. They are going into this question, and they would be finding out the solutions. First they will find out the problems, if any, then they will give the solutions. The Honorable Supreme Court is monitoring the whole issue, and we are giving everything to the Supreme Court that this is how we are conducting the examinations, and any genuine grievance of any student will be redressed, and the government stands committed to it. Of course, you agreed that this is not a part of the remit of this committee, but since you mentioned, it's good that I am also responding. Thank you, ma'am.
Thank you, sir. May I hand over the floor to Dr. Akino Vimal from the Ministry of External Affairs. Thank you.
Thank you. There was a question regarding a free, prior, and informed consent asked by one of the honorable members here, particularly related to scheduled tribe and the development projects. I think it's useful to clarify how we approach this issue. For us, the underlying principle is quite straightforward. Communities that are directly affected by projects should not simply be informed about decisions after it's already been taken. They should have an opportunity to understand what is proposed, what it is likely to impact may have on their land, livelihood, and way of life, and to participate meaningfully in the process. India already has a legal and institutional mechanisms through which such participation takes place, particularly through the local self-government institutions and the Gram Sabha, which is the village elected village councils in the scheduled areas, as well as through processes related to forest rights, land acquisition, environmental assessment, rehabilitation, and resettlement. While considering the legal rights, consultation, consent, and participation, and other considerations such as constitutional and statutory frameworks are also considered. This is broadly consistent with the discussion in the UN system on business and human rights. The emphasis has been on meaningful engagement with affected communities, identifying impact at an early stage, preventing or mitigating harm, and ensuring appropriate remedies which adversely impact, where adverse impact occurs. There was also a question related to mining. Well, I don't want to go into specific projects. I would like to clarify that India has comprehensive legal and institutional framework governing mineral concessions involving forest lands. Such projects are subject to multiple statutory safeguards, including approvals under the Forest Conservation Act, environmental clearance under the Environment Protection Act, and applicable environment regulations, as well as compliance with the Forest Rights Act. Importantly, the rights of forest dwellings, scheduled tribes, and other traditional forest dwellers must be addressed through the statutory process for recognition and settlement of forest rights. The Gram Sabha, which is the elected village councils, have the central role in this framework, including in protecting community forest resources and in process prescribed under applicable government guidelines before diversions of forest land is permitted. These are not merely administrative procedures. Compliance are subject to judicial scrutiny, and affected people and communities have access to appropriate remedies before the National Green Tribunal and Constitutional Court. And National Green Tribunal, in fact, is the highest court in India which deals with environmental issues. Thank you.
Thank you. There are, of course, still many questions that require substantive response. I'm acutely aware of the time. Let me just try to answer myself just a couple of issues that I meant. Perhaps my colleagues later on pick it up. On the issue of bonded labor, honorable member mentioned. Look, this is something we've been struggling with, to be honest, from independence. And I think we made good progress. Yes, unfortunate cases have come to light. It's a vast country. You said labor inspections didn't pick it up. There are cases where the inspections do pick it up. I don't know about the individual case you mentioned, but we take it very seriously. There is immediate assistance of money, rupees 30,000 and beyond. Rehabilitation assistance of 0.3 million to every rescued laborer. My data that I have says since the enactment of the Act, but that was 1976, 360 16,000 bonded laborers, a huge number, have been rescued. It's unfortunate that there were so many in bonded labor, with over 1 billion INR released, reimbursed. National Human Rights Commission, pursuant to Supreme Court directions, continues to monitor implementation. But you will always be able to come up with cases which unfortunately show that it's not fully done. But I can assure you the importance we attach, because this is a topic that goes back literally to our time of our independence. But I'm happy to see that the issue is now few and far between, that one case gets attention. The other element, which is a comment, I think was a query, that Dalit community was excluded from disaster response in some state. I would find that very difficult to believe. If one incident happened, I could understand. But disaster response is not community specific. The government wouldn't do it, and the National Disaster Response Authority force wouldn't do it. If there is a specific case, I would be surprised it hasn't been taken up in our legal system. But I assure you that's certainly not policy, and nothing that we do would even bring caste or any other thing in that. It's very difficult to understand that query. I don't have a response. I don't know if any of my colleagues has come across this. I would find it very difficult to say that. I know we have a few more issues. We have a couple of minutes less. Would you like to take the floor now or later after?
We can.
Okay.
So far as bonded labor is concerned, the legal and regulatory framework, India has already abolished the bonded labor system throughout the country, and Article 23 of the Constitution also prohibits the trafficking in human beings in any form. In addition to that, the principal legislation is Bonded Labor System Abolition Act 1976. Now, this act abolishes the bonded labor system, extinguishes bonded debt, fees, and bonded laborers from obligations arising from bonded labor, and renders agreements for or customs recurring bonded labor void. So all kind of practices through which bonded labor was practiced, all these practices have been abolished. It also protects the residential rights of the freed bonded laborers, and there is elaborate measures for their rehabilitation. They have been awarded land, they have been skilled, and they have been provided employment. So this is what I wanted to add for this. And so far as right to education is concerned, I would briefly like to mention that Section 12 of this Act defines very clearly who will be the beneficiary. It is the economically weaker section and disadvantaged group, including SCs and STs. Thank you.
Thank you. Thank you very much, Excellencies, and also members of the delegation, for providing all these answers to the questions raised. Now we will take a short break for 5 minutes, and then we will be back for the next phase, consisting of the questions raised by the rapporteur, co-rapporteur, and then we will wrap up. Thank you. 5 minutes break. welcome back. We will immediately start our last part of this meeting with the co-rapporteur, Madame Shepherd, raising questions on the segment 4. Madame Shepherd, you have the floor.
Chair, I want to join you, the rapporteur, Ms. Tavernaki, my fellow co-rapporteur, Ms. Chung, and all colleagues in really welcoming back India to CERD after some years of absence. It's nice to see you back with us. So my task is to engage a delegation in a conversation, a constructive dialogue around the situation of migrant workers, refugees, asylum seekers, and stateless persons under Articles 2, 5, and 6 of the ICERD, as well as human rights education to combat prejudice and intolerance under Article 7. And just for context, my specific responsibilities fall on the list of themes 27 to 33, just for you to know that. But I have to make an aside. I will tell you that as a historian from the Caribbean, a large part of my career has been spent lobbying for rights and respect for diasporan Indians, taken to the region by the former colonizers as indentured workers after the abolition of racialized chattel enslavement of Africans, and subjected to exploitation and contravention of the terms of their contract, including the right to repatriation. Their descendants are largely integrated now and have become important members of Caribbean societies. But the lingering legacies of colonialism still continue to manifest in some instances, and advocates continue to stand up for them. So now here I am having a conversation with what many in the Caribbean still consider to be their homeland. Anyway, like my colleagues, I know the information from the State Party and the National Human Rights Commission that the Constitution guarantees equality before the law and equal protection of the laws, Article 14, and expressly prohibits discrimination on the grounds of religion, race, caste, sex, or place of birth, Article 15. Also, that these guarantees are reinforced by Article 16, which provides for equality of opportunity in public employment, and Article 17, which abolishes untouchability. That these guarantees are operationalized through a wide body of legislation and public policies designed to protect vulnerable and marginalized groups, including scheduled castes, scheduled tribes, and religious minorities. However, in some cases, there appears to be a disconnect between written legislation and its implementation. For example, with respect to the situation of scheduled castes and scheduled tribes, we heard from civil society organizations that discrimination on the intersectional grounds of race, caste, and gender in the world of work remain deeply ingrained in Indian society. So my hope is that this interactive dialogue will clarify and amplify areas of disconnect for us. So let me start with list of theme 27 and ask for updated information on the legislative and policy frameworks relating to migrants, refugees, and asylum seekers to ensure their access to justice, education, employment, and health services without discrimination. We have learned that all foreign nationals, including refugees and asylum seekers, are governed by the provisions contained in the Constitution of India, the Foreigners Act 1946, the Registration of Foreigners Act 1939, the Passport Entry to India Act 1920, and various other legislation. But can you elaborate on the issue of voluntary repatriation for us? Does it exceed the percentage of state deportation? Because you talk about rights that do not include the right to reside and settle in the country, which are applicable only to the citizens of the country. That aliens in India are not expelled except in accordance with the procedures established by law. But I still am asking about this, an elaboration on the issue of voluntary repatriation, and does it exceed the percentage of state deportation? In defense of deportation of refugees, migrants, and asylum seekers, the state has said that humanitarian endeavor must be consistent with its goals of welfare of its citizens and national security. So what have been the major challenges encountered that would have led to this statement? We have learned that children born of migrants and asylum seekers are not given citizenship and are at risk of being stateless. So what measures have the state taken to prevent and protect people from statelessness, including statistics on stateless persons and those at risk of statelessness? I have some additional questions. Could the delegation explain what safeguards exist under the Immigration and Foreigners Act 2025 to ensure that the detention, removal, and treatment of foreign nationals, including refugees and asylum seekers, are fully consistent with Articles 2 and 5 of the Convention and protected against racial discrimination? Could the delegation clarify whether the government is considering amending the Immigration and Foreigners Act 2025 to establish clear guidelines, clear safeguards for vulnerable groups, including asylum seekers, refugees, children, victims of trafficking, and stateless persons? Given that irregular entry may lead to criminal sanctions under the Immigration and Foreigners Act, could the delegation explain how such provisions are compatible with the principle of non-discrimination when applied to persons seeking international protection? According to information before the committee, the Immigration and Foreigners Act does not appear to establish a maximum period of immigration detention. Reports indicate that some individuals, including refugees from Myanmar, have remained in detention for prolonged periods after completing criminal sentences related to irregular entry. Could the delegation provide information on the legal basis governing the duration of immigration detention and indicate whether there is a statutory maximum period of detention? Could the delegation provide updated statistics disaggregated by nationality, ethnicity, religion, sex, age, and detention facility on the number of persons currently held in immigration detention, including refugees and asylum seekers? And what measures have been taken to ensure that immigration detention is not prolonged or indefinite, and that detainees have effective access to judicial review of their detention? Now, turning to access to healthcare and education, according to information before the committee, sections 9 and 10 of the Immigration and Foreigners Act impose reporting obligations on educational and medical institutions regarding foreign nationals. Concerns have been raised that these provisions may discourage migrants, refugees, and asylum seekers from accessing essential services. Could the delegation clarify how these reporting obligations are implemented in practice and what measures are in place to ensure that migrants, refugees, and asylum seekers are not denied or deterred from accessing health care and education on discriminatory grounds? Now, according to, based on the concluding observations 2007, which expressed concern that India has not acceded to the 1951 Refugee Convention and its 1967 Protocol and has not adopted specific refugee legislation, and the list of issues 2021, which requested information on measures to adopt national refugee and statelessness legislation and end the indefinite detention of Rohingya. And given the committee's long-standing concern, has the state party taken any step towards acceding to the 1951 Refugee Convention or enacting national refugee legislation since 2007? If not, what is the timeline for doing so? What specific measures are in place to prevent statelessness for children born in India, the refugees, asylum seekers, or stateless parents, particularly for those who may otherwise become stateless due to inability to acquire citizenship from their parents' country of origin? Now, based on the list of issues 2021, which requested information on ending indefinite detention of Rohingya and ensuring compliance with non-refoulement, and the State Party Report 2023, which references the Supreme Court's decision upholding deportations, what specific procedures and safeguards are in place to ensure that persons seeking international protection at India's borders or within its territory have access to asylum procedures? What safeguards are in place to ensure that persons seeking international protection of India's borders or within its territory are not returned to countries where they face a real risk of persecution, torture, or serious harm in compliance with Article 5B of the Convention? How many individuals seeking international protection have been denied entry, detained, or deported since 2019, disaggregated by basis of claim, if you have such data? And what mechanisms exist for investigating allegations of excessive use of force or violence by law enforcement agents against migrants, refugees, and asylum seekers? Based on the State Party Report 2023, which states India is not a signatory to the 1951 Refugee Convention that all foreign nationals are governed by the Foreigners Act 1946 and the Citizenship Act 1955, and in the absence of national refugee legislation and accession to the 1951 Convention, what legal framework governs the determination of refugee status and the protection of individuals in need of international protection? What mechanisms are in place to ensure that individuals are not expelled or subjected to refoulement without an individual assessment of their protection needs? Now, staying with the issue of Rohingya who fled Myanmar to India. Now, based on the Rohingya Letter 2018, which requested India to comply with non-refoulement, the List of Issues 2021, which requested information on ending the indefinite detention of Rohingya and ensuring compliance with non-refoulement, the Third Statement 2024, which regrets India's lack of response, expresses alarm about arbitrary mass detention, including children, forcible deportations, racial discrimination in access to services, and the spread of hate speech by politicians. And the State Party Report 2023, which references the Supreme Court's decision upholding deportations. What are the conditions of the detention and for how long have they been held? What alternatives to detention have been implemented for Rohingya individuals, including women, children, and families? What measures has the State Party taken to provide Rohingya refugees with access to basic services, including education, employment, and health care without discrimination? And are they provided with legal representation and an opportunity to challenge deportation decisions before an independent body? Now, list of themes number 30, measures taken or envisaged to combat acts of racial discrimination, hate speech, and violent attack against migrants, refugees, asylum seekers, and stateless persons, including by addressing its root causes, as well as information on the investigation of incidents of racial discrimination and violence against migrants, refugees, asylum seekers, and stateless persons, and to bring perpetrators to justice and provide victims or their families with effective remedies. Now, based on the List of Issues 2021, which requested information on measures to combat hate speech and racially motivated attacks against groups, including the Rohingya, Africans, Northeastern communities, and scheduled castes and scheduled tribes communities, and the State Party Report 2023, which states that racially motivated actions are not specifically codified as aggravating circumstances, and it describes attacks on Africans as individual criminal acts rather than racist attacks. What specific measures has the State Party taken to prevent and respond to racially motivated attacks against African nationals, Rohingya, and other migrant communities? Now, based on the Common Core Document 2022, which states that sections 153A, 153B, and 5052 of the IPC criminalize incitement of hatred on grounds including race. Can you say how many cases of hate speech against migrants have been prosecuted under those sections that I mentioned? In terms of list of Issues 31, measures to prevent, taken to prevent and protect people from statelessness, Please provide updated statistics of the number of stateless persons and persons at risk of statelessness in India, disaggregated by age, gender, ethnicity, and region. Now, in terms of education, because I'm watching the time, so let me go to education, human rights education, to combat prejudice and intolerance. Based on the concluding observations 2007, which noted that caste bias and racial / ethnic prejudice remain deeply entrenched, and the list of issues 2021, which requested information on measures to eradicate the social acceptance of caste-based discrimination and racial prejudice. What public education and awareness campaigns has the state party conducted since you last appeared before us to combat the social acceptance of caste-based discrimination and racial, ethnic, and ethno-religious prejudice? And all this in connection with the issue of education and training. What training programs are in place for civil servants, law enforcement officers, and judicial authorities to raise awareness about the importance of racial, ethnic, ethno-religious, and cultural diversity and tolerance, and to prevent discrimination in the delivery of public services? Now, we have government data which reveal a steep caste hierarchy within India's higher education institutions. Professors in central universities, as of April 2023, we learn only of the professors, of 1,341 professors, only 7.2% were scheduled from the scheduled caste, against a statutory reservation benchmark of 15%. So the shortfall widens at each higher rank, indicating that reservation in promotion is not being delivered. And I also wanted to find out about the curriculum at all levels of the education system, especially the lower levels, in terms of what they say about human rights education. The State Party 2023 submission notes that under the National Education Policy, regular audits on the curriculum are performed to advance mutual respect. So what criteria are set by the state to be used in these audits to ensure preservation of historically accurate information on the contributions of scheduled castes and scheduled tribes? What measures have the state taken to address allegations that textbook chapters covering inequality, social justice movements, and caste oppression are being diluted or omitted? And given the implementation of the University Grants Commission, UGC, anti-discrimination frameworks, how has the government moved to address the high dropout rates and student suicides linked to institutional caste discrimination at elite universities? And finally, this state party has noted that mandatory human rights training is done at national police and civil service academies. Do these programs include any specific modules designed and intended to deep-seated caste biases and profiling? So I'll stop there, Chair, and hope to have some interactive dialogue with the delegation. And please remember that you know your country a lot better than we do, but we do have the benefit of discussions with knowledgeable academics and civil society groups, and we have read some of widely about your country. But we depend on you to clarify for us some of the issues that we have raised, and let us learn from each other as we go through this dialogue today. Thank you very much.
Thank you, Madam Shepherd. You have a bit more than 1 minute to intervene if you'd like during the replies to ask for clarifications. I immediately turn the floor to the delegation for responses. You have the floor, sir.
I'm scared to take the floor, Excellency, because I thought we were going to try to address some of the questions we couldn't answer in the previous session, and now I have 2 dozen questions from Madam Shepherd. We will try our best. I've just noted it down. Thank you, ma'am. Appreciate your enthusiasm and focus on issues that we share deeply with some of the issues that you mentioned. Let me first try to address some of the key issues that we didn't answer in the previous session. So for that, may I give the floor to Solicitor?
I'd like to address on two issues raised by the Honorable Rapporteur. First was regarding reservation in the higher judiciary. The country's stand is consistent that we believe in reservation for those disadvantaged sections of the society, and the government is committed to it. But we must understand the distinction between constitutional offices and non-constitutional offices. So far as higher judiciary is concerned, namely judges of the High Court and the Honorable Supreme Court, they are constitutional functionaries. In the system which we follow in India, we have a collegium system where for elevation to the High Court, the first three judges in line of seniority, the Chief Justice, number 2 and number 3. And in case of elevation in the Supreme Court, the Honorable Chief Justice of India and first 4 judges, they take a decision who is to be elevated based on several factors, including merits, but we do not go by the percentage or reservation criteria. But I must tell you from experience that the factor of a person belonging to either scheduled caste or scheduled tribe, etc., is taken into consideration by the collegium, and if everything is equal, he gets benefit of belonging to that particular disadvantaged group. But this is not to dilute the commitment of the government that reservation is required, and in all non-constitutional offices, it is a matter of policy, and that is all I can say, that reservation is the policy of the government. Second question which fell from the Honorable Member was regarding hate speech by some senior officials. See, we do not go by the offender, we go by the offense. Hate speech is treated as a very, very serious offense, requiring severe punishment, but in accordance with law. Who is indulging into hate speech is irrelevant, whether he is a common citizen or a senior official. He is facing the law of the land, and for some reason, if the law is not reaching him, then we have human rights defenders who do file petitions in the Supreme Court and the High Court seeking appropriate actions. And the Supreme Court, as I've already said, has laid down a detailed guidelines, and Supreme Court do issue effective directions to ensure that whoever indulges into hate speech is brought to the book. Thank you.
Thank you, sir. I think we had, maybe I would on human rights education turn to Ambassador Ajungla Jamir, our Deputy Permanent Representative. Ma'am, you have the floor.
Thank you. Mr. Chair, human rights education is an important part of India's efforts to promote equality, dignity, and respect for diversity. It extends from schools and universities to the training of police, security personnel, judicial officers, and other public officials. At the school level, the National Education Policy 2020 and the National Curriculum Framework for School Education 2023 place constitutional and human values, respect for diversity, equity, and inclusion at the center of education. The framework also seeks to develop in students a responsible commitment to human rights. These principles are being reflected in new textbooks and learning materials, alongside the teaching of civics and legal studies. India also places emphasis on preparing teachers to create inclusive and non-discriminatory learning environments. Through the National Initiative for School Heads and Teachers' Holistic Advancement, in short from NISHTA, teacher training program, large numbers of teachers have received training on equitable and inclusive education, including addressing social and educational barriers faced by disadvantaged children. At a higher education level, the University Grants Commission, the statutory body established by an act of parliament, issued guidelines on inculcation of human values and professional ethics in higher education institutions, known as Mulya Parva 2.0, which promotes human values and professional ethics in higher education. It provides for courses covering constitutional values, fundamental duties, and citizenship values. Human rights also form an important part of legal education, including in national law universities and law colleges in India. Mr. Chair, human rights education is not limited to formal education. The National Human Rights Commission has an important statutory role in spreading human rights literacy. It conducts internships, training programs, seminars, and other outreach activities for students, educators, law enforcement personnel, and public officials. During 2023 to 24, the Commission also supported collaborative training programs involving central universities and police and judicial training institutions. India also promotes greater understanding of its diversity initiated by the Ministry of Education through initiatives such as Ek Bharat Shrestha Bharat, One India, Great India, and Yuva Sangam, Youth Conference, which encourage cultural, linguistic, and educational exchanges among provincial governments. These initiatives seek to counter stereotypes and foster respect for India's diversity. Special attention is also taken to sensitizing law enforcement and judicial authorities. The Bureau of Police Research and Development conducts training on anti-discrimination laws and the protection of vulnerable groups. National Human Rights Commission has conducted training of trainers programs for police, Central Armed Police Forces, investigating agencies, and prison officers. Judicial training institutions also conduct programs on constitutional values, equality, diversity, and access to justice. Mr. Chair, India believes that human rights education should go beyond textbooks. It should cultivate respect for human dignity, equality, non-discrimination, and diversity in everyday life. Our approach is therefore to build a culture of human rights through education, public awareness, and professional training so that these values are understood, respected, and practiced across generations. I thank you, Mr. Chair.
Thank you, Ambassador. May I now give the floor to Madam Nishta from MHA to supplement this? Thank you.
Mr. Chair and esteemed members, I would like, in addition to the comments of my distinguished colleague, we would like to add upon the training and capacity building of law enforcement agencies on the issues of human right, and which has come up into various points raised by the esteemed members. It is my pleasure to inform that India has approximately 3.5 million police personnel nationally, as per Bureau of Police Research and Development data on Police Organization 2022-23. All of them, all the police personnel are trained under new criminal laws. This is the largest single law enforcement training exercise in India's history. It is being conducted through BPRND, State Police Training Academies, and National Judicial Academy. Modules include the zero FIR obligation, directly relevant to SC/ST victims who were historically, it is alleged that denied FIR registration or jurisdictional grounds. Further, I would like to come upon the training on human rights issues. Sensitization of the police on human rights and non-discrimination is institutionalized through Bureau of Police Research and Development, which is the government's apex training body. In 2025-26 alone, BPRND and its outlying units conducted 1,283 courses, training 78,881 officials nationwide, spanning senior leadership, investigators, prosecutors, forensic personnel, etc. Over the preceding 5 years, 2,463 domestic courses trained over nearly 0.23 million police personnel through centers for detective training and Central Academy for Police Training across every region of the country. It shows that human rights training is embedded structurally, not incidental. Vertical interaction courses for senior police officers explicitly cover public order and human rights. CDTI, which is called Central Detective Training Institute, Kolkata, has been designated the National Center of Excellence for Community Policing and Crime Against Women, Children, and other vulnerable sections, and has separately conducted 12 courses training 274 officers specifically on human rights. The Developing a Specialist Investigator Scheme mandates at least 2 trained specialist investigators in every district of every province and union territory, ensuring districts with significant scheduled castes, scheduled tribes, and minority population receive the same trained investigative capacity as any other. Women's safety courses alone trained 2,672 officers in 2025-26. Together, these reflect a sustained nationwide investment running into hundreds of millions of rupees in professional, right-respecting, and non-discriminating policing. In short, the 2025-26 figures break down figures for law enforcement agencies training is as follows. 619 domestic courses trained 54,916 officials. 204 courses on new Nyaya Sanhita framework trained 17,488 officials. 329 coordinated courses with armed forces and central armed forces police forces trained 1,764 personnel. And there are likewise many other courses which have trained the entire police force of 3.5 million. Thank you.
Thank you, ma'am. Before I hand over the floor to Honorable Solicitor General regarding the queries on the legal aspects of refugees, etc., just a quick comment I wanted to make on a query that came up on actions or attacks against specific groups. We have been trying to answer this question for the last couple of days since yesterday on scheduled castes, scheduled tribes, other groups. Now, it's easy to put them all together and say what's the process. Each one has a different one. But esteemed member referred to the issue of people of African descent in India. Since you took went back into history, may I also go back into history a bit to say I don't think the India's commitment to apartheid or discrimination on the basis of skin color is in doubt, and that is not a government position. It's a position of the nation. So I don't know if you have too many people of African descent in India, but we have a lot of students, certainly. And yesterday, I think my colleague did mention a little bit about measures that we take. But I wanted to assure you that on that issue, each case is taken seriously. They may not be related to attack racially because it's not as if they're living there. They're there for a few years, they're going back. But each case that is there, we are in touch with the concerned governments, their embassies. We have a process where they're assisted. We are understanding that for us, the students are welcome in our country. They should not be feeling any difficulty. And to be honest, I don't hear too many cases. A couple of times the cases come up and they get attention. But as a nation, I think this is something we very strongly about, that we need to work to ensure that everybody has a very comfortable, very welcoming situation. I don't think the numbers are as large as to say the percentage of population, how they're being treated, but I will stop here. And if there are any follow-up questions on that aspect or others, I'm happy to try to see. But for the moment, let me hand over to Solicitor General. Thank you.
I'll answer the questions concerning the policy of immigration, refugees, etc. Now, I would request the honorable members of the committee to bear in mind certain geographical factors which are India specific, and certain historical perspective, which are also India specific. So whenever a nation makes the laws with regard to dealing with citizens, refugees, or illegal immigrants, all these factors go into consideration, and everything is governed by the statutory law, which is made by the competent legislature, in this case, the Parliament of India. First of all, I must make it clear that India is not a party to the 1951 United Nations Convention relating to the status of refugees. We are also not party to 1967 Protocol on Refugees. So essentially, we are governed by the statutory mechanism and the statutory framework framed by the Parliament of India. And all these frameworks and the statutes are tested by our constitutional courts and on the touchstone of fundamental rights of everyone, including non-citizens, and they are upheld by the constitutional courts on more than one occasions. Now, all foreign nationals, including refugees, migrants, and asylum seekers, are governed by the provisions contained in Immigration and Foreigners Act 2025, as the Honorable Rapporteur mentioned, which came into force in September 2025. The earlier regime was a pre-existing colonial regime, that was Passport Entry into India Act 1920, Registration of Foreigners Act 1939, and the Foreigners Act 1946, and the Immigration Careers Liability Act 2000. Now, new law has drastically made it modern and transparent framework. We have a now Bureau of Immigration, Bureau state level enforcement, which may not be uniform at times. Now it would be uniform. The core operative provisions of the Act, including registration on arrival into the territory of India, penalties for using forged documents, restrictions on entry to sensitive sectors, apply to foreign nationals as a category, which is a classification made by law, without reference to any race, religion, nationality, or origin. What happens is, we've experienced this many a times, that people who try to come into India illegally, they become victims of certain individuals or certain vested interest groups who use them as couriers for drug trafficking or some other illegal things to be brought into India, etc. And therefore, we have a robust mechanism to ensure that they are dealt with strictly in accordance with law. So far as the question of torture is concerned, I am happy to inform that there has been no torture of the people who are found to be illegal immigrants. Those who are in the detention centers, they are given all basic human necessities like nutritional food, they are giving legal aid, they are being given medical care, and so far as the constitutional framework is concerned, Article 14, which is right against non-arbitrary action or non-discrimination, and Article 21, which is right to live freely, subject to the law of the land, is available to all, even if non-citizens. So they are all governed by these two constitutional provisions, which is a part of their fundamental rights. One aspect which I missed yesterday was regarding left-wing extremism. There was a question that there is a possibility of reward for killing, which is not a correct factual assertion. As a matter of fact, I'm very happy to inform that most of the left-wing extremists have surrendered voluntarily and at times with the active support of the civil society organizations. And this is applauded by the local population, which is mostly the tribal population, because now whatever benefits were available to rest of the India and which were not reaching them because of the extremism, left-wing extremism, has started reaching them. So the tribal population is very happy. Thank you.
I think we're out of time. So
Thank you. Thank you. Thank you very much, Excellencies. I will now open the floor for follow-up questions by the country task force and also the members. We have 15 minutes for that, and I'll give the floor to Madam Shepherd first.
Taking the promised 1 minute, almost 2 minutes that you promised to give me back. So thank you very much, delegation, for your responses. Let me start by saying that the reference to going back to the past didn't escape me. But as a historian, you know, you know that the past informs the present and also can help to guide us to the future. So I'm not upset about your snide remarks at historians. It didn't escape me. I also wanted to say that I did start by admitting that India has some very good legislation to address some of the ills of the society that we have pointed out. However, we're all used to the politics of should. So the legislation should have this impact. The legislation should have the other impact. My concern is how effective have the legislation been in one area or the other? What are you seeing? Are you seeing the impact that you desire from the legislation that you have passed in various areas, for example, towards refugees, migrants, and people who are seeking asylum? Have you seen it reducing the number of people who we call stateless persons? Have you seen changes in the education system? Have you seen changes in terms of the impact of your human rights education? So those are my concerns. Good legislation. Have you seen changes in the society? For example, reduction in xenophobic actions and prejudices against foreigners, people called foreigners. These are my concerns. Thank you.
Thank you. Madam Chung, would you like to take the floor? You have the floor, madam.
Quick question. Thank you very much for your clarification, but I have questions on statelessness issue. We received many reports on Bengali-speaking Muslim and Kashmir who could not receive citizenship and became stateless. Could you provide the clarification on this? Thank you very much.
Thank you. Madam Stavrinaki.
Thank you, Chair, and many thanks for the responses. I have a very brief question on the detention centers of migrants and non-citizens. Is there a specific inspection mechanism? Because we see a lot, also as well, a lot of abuse in these places. And, you know, how is this also, I mean, building on my co-rapporteur's question, how is legislation, for instance, on maximum of detention is enforced? And again, I would like to repeat my kind request. If we have specific data and numbers on hate speech cases, where, for instance, you know, come also, you know, law offenders are high officials, please do submit them, or do submit any kind of data that is, for us, important to understand how law is enforced in practice. Thank you very much.
Thank you. Madam Bokar-Wilson.
Thank you, Mr. Chair. Mr. Chair, kindly permit me to comment on a position just proffered by the state party regarding hate speech and their focus on the crime as opposed to the doer of the crime, if I heard, if I heard correctly. The reason this committee recommends placing emphasis on both the crime and the doer of the crime is that for the purpose of punitive measures and sentencing, you as a state party would have to establish mitigating or aggravating circumstances based on the doer of the act, right? So let's say, for example, if the perpetrator is an authoritative or manipulative speaker in opposition to effectively influence the conduct of other persons, then yes, that would be an aggravating circumstance, and that would be reason enough to pay attention to the doer. At the same time, if the victims are, say, for example, young persons indoctrinated into a group-based hatred or a vulnerable and susceptible audience like youth and children, that will also be relevant. Thank you, Mr. Chair.
Thank you. Monsieur Diaby, vous avez la parole.
Merci, Monsieur le Président.
Chair, thank you. I would like to react to what was said about the vestiges of colonialisms, the remnants of colonialism, which the co-rapporteur referred to. We know that India was the first country to put racism on the UN's agenda in 1946 by bringing a complaint against discriminatory treatment of persons of Indian origin in South Africa. And its first session, the General Assembly adopted on the 8th of December of that same year, Resolution 44/1, saying that this treatment should be subject to the international obligations, subject to the UN Charter. Historically, India and the African continent have experienced tragic destinies in the past, the transatlantic slave trade and colonialism. So we would like to know the following. How do the Indian authorities see the future in terms of supporting CERD in its quest to secure justice for crimes against humanity perpetrated through the transatlantic slave trade and colonialism? Also, what national strategies has India adopted to promote the second decade of persons of African descent program? Could you give us statistics about persons of African descent who live in India? Thank you very much.
Thank you, Mr. Chair. Well, I have perhaps more like a brief comment than a question, but who knows, maybe there will be a question after all. The thing is that I was listening very carefully to all answers and all parts of this dialogue, also those concerning Article 7 and education. I think we would agree that each part and each provision of ICET matters. There are no more or less important parts. Article 7 of ICET, which concerns education, happens to be the last in part 1, but it's equally important. You provided us with feedback and information in this regard, but this brings me also to this thought that indeed it's never enough to stress the importance of it. I particularly appreciate one of your members of the delegation saying that human rights education should go beyond textbooks. Absolutely. And I would also say in this regard that, well, I know there are good human rights centers in India. I know that there are a lot of projects going on. However, I was wondering to which extent does the government has any competence or any kind of possibility to influence university curricula when it comes to this general human rights education? Well, in other words, universities normally have a lot of competence and possibility and autonomy, and they should have. But I was wondering if it's so that you could tell us whether government may have the specific instruments to encourage the presence of human rights agenda in university curricula. Lastly, I have a remark, perhaps more like a voice in the discussion, and maybe even more to my fellow colleagues at the committee, because we have recently produced very important general recommendations. There are some important general recommendations coming in the pipeline. I wanted to share with you that maybe Article 7 and the issues of education, teaching, culture, maybe they also deserve our attention at some point, to look closely at these standards, to look at their dynamics, and maybe this is a way to go. I am not saying we have neglected it. I think that we paid due attention to issues concerning education, but nevertheless, I just wanted to put it on record that at some point we should also consider how to update our standards here. Thank you, Mr. Chair.
Thank you. Madam Shepherd, you have the floor.
Thank you, Chair. This is just really piggybacking on Mr. Balchazak's comments about general recommendation, because I think if it was mentioned before, it bears repeating that General Recommendation 38 and General Recommendation 39 address the issues, the obligations of states in terms of, or we're encouraging states to implement some of the recommendations in GR 38 and 39 with respect to migrants, refugees, and asylum seekers. So I just wanted to flag those two. We did these in collaboration. I think Mr. Gissé would have mentioned this had he been in the room, because he worked very hard on these general recommendations or general comment, because we did it in collaboration with the Committee on Migrant Workers. So you may want to have a look at that at some point as you continue to address the issues facing migrants, refugees, and asylum seekers. Thank you, Chair.
Thank you very much. The floor is still open. I don't see anybody asking for it. So we have about 3.5 minutes. I'm going to turn to the delegation for their responses, but the members can use these 3.5 minutes to intervene if you need further clarification during this time. So over to you, sir. You have 20 minutes.
Thank you. Thank you, Chair. Thank you for the questions. Before I turn to others, let me just apologize if there's been a miscommunication to Madam Shepherd. I don't mean das Nein-Debug at all. I just wanted to emphasize that discrimination against people of African descent is a matter of national faith. If there are actions that happen, it's something that we need to fix. It's very rare, that's why I said we believe in it as a nation. Having said that, I don't know if there is actually a number for that. There are people who have been in India for centuries called Siddhi people. They are of African descent. I don't know. In India, 100,000 is not a big number, so I would say about 100,000 people maybe. African students, we have a much better fix. We can try to get you, because they come, they are on visas. But if you say African descent, again, goes back to that original indigenous people, who's of which descent. But certainly, we haven't heard any particular cases of discrimination in that from that perspective. There have been incidents against some students of Africa, but as my colleague explained, those have been specific incidents related to problems between students. It's not so much against society. Having said that, let me now hand over the floor to perhaps Madam Mona from Social Justice. Thank you.
Mr. Chair, I would like to mention, in addition to the police training and capacity building, the awareness programs undertaken, and also the protection extended to victims and witnesses. So the institutional measures for capacity building strengthen the capacity of law enforcement agencies to apply laws impartially, protect vulnerable communities. But India has strengthened access to justice through the National Legal Services Authority and the State and District Legal Services Authorities Act 1987. Every member of an SC and ST community is eligible for free legal services irrespective of income. Victims of caste atrocities are also expressly covered as persons entitled to legal assistance. Victims and witnesses, they are specifically provided more assistance, like ensuring their travel and bearing their travel expenses and giving them special protection. Significant institutional development was the Memorandum of Understanding signed on 30th September 2024 between the Department of Social Justice and Empowerment and NALSA. Under the MOU and the associated Sarathi ones and district legal service authorities conduct legal awareness and outreach programs through panel lawyers and paralegal volunteers concerning inter alia, the PCR Act, POA Act, and prohibition of employment as manual scavengers and the Rehabilitation Act. The partnership is intended to improve awareness of rights, access to legal assistance, and access to welfare schemes. Institutions from the Supreme Court and High Courts to state, district, and block levels of judiciary during financial year 2025-26. NALSA reported 1.6 advice vegan persons, including queries raised discrimination by private persons. So I would like to mention that so far as the statutory provisions of it, as well as public persons or public, is same for everyone. Now, if we talk about the welfare programs or ensuring that private sector as well, so I would like to mention that in a democratic and diverse country like India, we have to work a lot through persuasion. Here I would also touch upon RT Act. RT Act provides for 25% reservation in private schools. And there was a query that why segregated data on SC and ST are not maintained under RT Act.